Chapter 10 of Indian Contract Act Agency Section 182 to 238 Last chapter. It is an absolute proposition of law that in a contractual relationship of a principal and an agent, the principal is always bound by the acts of the agent, and an agent takes no rights to incur no personal liability under a contract entered into by him as an agent of the principal with third person. No, an agent will be personally liable only when he does not discloses the name of the principal, and when the name is disclosed but principal cannot be sued for reason provided in law. A, without authority of B, lends money of B to C. Afterward, B accepts interest on money from C. What does B's conduct lend to C? Agency by ratification. Reference is section 197 illustration 2. Under section 182 of Contract Act 1872, National Textile Corporation Limited is answer, nor an agent of the central government. A person employed to do an act for another or to respect another in dealing with third person is a pawner. An agent can be appointed by a measure of sound mind. Reference section 183. To create an agency, consideration is not necessary. Moshe versus McFarlane, 1555 to 1774. The case is relating to test of agency. The term agent is defined in Indian Contract Act under section 182 of the Act. Indian Contract Act, in which one of the following consideration is not required? Contract of agency. Reference section 185. Which statement is wrong regarding agency under law of India, Indian law of contract? Consideration is not necessary to create agency. Section 185. In which one of the following type of contract consideration is not necessary? Agency. Which one of the following statement is correct? The liability of master and servant is joint and several. Which one of the following statement is incorrect? The authority of agent may be implied. This one is right. Consideration is necessary to create an agency. Wrong. Only a person of majority can become an agent. Right. In emergency, an agent has authority to do all the act for the purpose of protecting his principal right. No consideration is necessary to create an agency. Who may be employed an agent? Answer: any major and person of sound mind. Which one of the following is not a type of agent? All are not a type of agent. Dill, Federal, Pakka, Digital, Broker, Factor. All are not agent. All of the above are not agents. In Cox versus Hickman 1960, Lord Wensleydale held that law relating to partnership is a branch of law relating to principal and agent. Subletting is responsible for his act to the agent but not the principal. Find the correct option with reference of Contract Act. Answer: the statement is true and the provision in regarding there is in section 192. A direct B to sell his estate by auction and to employ an auctioneer for the purpose. B names C an auctioneer to conduct the sale. C is not sub-agent but A is agent for the conduct of the sale. Reference section 194 illustration A. In which case sub-agent lawfully appointed, which one of the following is correct? As regard the third party, the sub-agent bind the principal as an original agent can bind. This one is right. Reference section 191. In which one the following case conditions can be agent, sub-delegated his authority to another person. When the commercial practice involved in such delegation. In which one the following statement is correct in relation to sub-agent? He is employed by original agent in the business of the agency. A person employed by and acting under control of original agent in the business of agency is sub-agent. A sub-agent is responsible to the principal on which one the following ground? Willful wrong or negligence. The effect of rectification under the law of agency is retrospective. Reference to section 199. An agency under Contract Act is terminated by D. All of the above. Principal revoking his authority, death of either part, principal or agent, principal being adjudicated and insolvent. Reference to section 201. Under Indian Contract Act 1872, an agency shall stand terminated in the below mentioned case: death and insolvency of principal. A give authority to B to sell A's land and to pay himself out of the proceed the debt due to him from A in absence of express contract. cannot revoke this authority nor can be terminated by his death or insanity. Reference section 202 illustration A. A indict B to B his authorized B he authorized B to sell his house and to pay himself out of the sale produce the debt due to him. In absence of express contract, both B and C are correct. A cannot revoke the agency. Agency is not terminated by A's death. In Sikriya Cotton Mile Limited versus State of Bombay, Supreme Court described the role of decedral agent. Assertion. Relation of partner inter se is that of principal and agent, right? The rule of law of agency does not apply in the case of their liability is wrong. C is right. A employs B to recover 100,000 rupees from C. Through B's misconduct, the money is not recovered. B is entitled to no remuneration and must make good the loss. Reference section 220. A employ B to beat C and agree indemnify him against all consequences of the act. B thereupon beats C and pay damages to C for doing so. A is not liable to indemnify B for these damages. Section 220 reference. An agent cannot be remunerated his mistake under section. Remuneration for his misconduct under section 220. In a suit filed by agent under general contract of agency maintainable at his instance. No. T. Coach M, a minor who is a student in secondary school in mathematics. Though there was no talk between the father of M and T with respect of remuneration to be paid to T, yet the father of M had knowledge of the coaching imparted by T. After M succeeded in exam, T demanded remuneration from father M. Which legal principle would be governed in this case at hand? T would be entitled for recovery from father, since father of M has enjoyed the benefit of non-gratuitous act, that being coaching of M. B. The proprietor of newspaper publisher, at the request liable upon C in the paper. A agreed to indemnify B against the consequences of the publication and all cost of damage and action in respect thereof. B is sued by C and has to pay damage and also incurs expenses. Decide in the light of section 224 of the Indian Contract Act. A is not liable to be upon indemnify. Which one of the following is correct statement? An agent is not liable for the act to disclose principal subject to the contract to the contrary. An agent at a time of making the contract does not disclose the name and address of his principal, but it comes to the known to the secondary party afterward. in case of any default of secondary party may file suit against either agent or principal or both. The principle of agency is necessity is the principle of agency of necessity is applicable in emergent situation where communication was the principle is not possible. A consigns goods to B for sale and give him instruction not to sell under a fixed price. C, being ignorant of the instruction given to B, enter into a contract with B to buy the good at the price lower than the reserve price. A is bound by that contract. Reference section 195 illustration B. X entrusted Y with the negotiable instrument endorsed in back. Y sell them to Z violating the private order of X. The sale is valid. In which one of the following condition can the agent subdelegated his authority to another person? When commercial practice involves such delegation. Indian Contract Act. A enter into a contract with B to sell his 100 bales of cotton, and afterward discovered that B was acting as an agent of C. For the price of cotton, A may sue against B and C both. A person appointed by the agent under authority of principal is known as substituted agent, decidal agent. Decidal agent is a kind of mercantile agent. Under Indian Contract Act 1872, the following right is not available to the agent. Right to sale. Under Indian Contract Act, in which one of the following cases the presumption of agent personal liability does not arise? Where the agent contract with a party who knows that principal is a minor. A, the captain of a ship sign a bill of lading without having received on board the good mentioned therein. As between B and pretending cosigner is concerned, the bill of lading are void. Reference to section 238 illustration B. When the agent of contract without disclosing the name of existing of the principal, in such case on knowing about the principal, third party may file suit against either agent or principal or both.